More than 10 years after the Obergefell decision, the Tennessee legislature is considering pushing back on part of this judicial overreach. To start with, we have to realize that it's still the policy of the state of Tennessee to only recognize opposite-sex marriage. From the Tennessee Code annotated section 36-3.113 reads, Tennessee's marriage licensing laws reinforce, carry forward, and make explicit the long-standing public policy of this state to recognize the family as essential to social and economic order and the common good and as the fundamental building block of our society. To that end, it is further public policy of this state that the historical institution and legal contract solemnizing the relationship of one man and one woman shall be the only legally recognized marital contract in this state in order to provide the unique and exclusive rights and privileges to marriage. The legal union in matrimony of only one man and one woman shall be the only recognized marriage in this state. Now, as I understand it, various state agencies and subdivisions do issue and recognize same-sex marriage licenses due to the Obergefell decision. However, HB 1473 would codify the limitation of that decision, be it enacted by the General Assembly of the state of Tennessee. Tennessee Code annotated section 36-3.113 is amended by adding the following new subsection. Private citizens and organizations are not bound by the 14th Amendment or by the Supreme Court's purported interpretation of the 14th Amendment in Obergefell v. Hodges. And no private citizen or organization in this state is required to recognize a marriage or a purported marriage between individuals of the same sex, notwithstanding any other law. Have you ever had one of those moments when the truth just simply explodes in your head? That was my reaction when I first read this legislation. Now, I'm sure someone out there is saying, but wait, Paul, the Constitution is the supreme law of the land. How can a state simply ignore it? However, it's not ignoring the Constitution. It's being aware of the details. For example, Section 1 of the 14th Amendment, which the Obergefell Court based their decision on, states, nor shall any state deprive any person of life, liberty, or property without due process of law. HB 1473 is correct that the 14th Amendment binds states, not private citizens or organizations. And since the Supreme Court cannot make law or amend the Constitution, their decisions based on the 14th Amendment similarly cannot be binding on private citizens or organizations. HB 1473 also deals with the Board of Judicial Conduct. Tennessee Code annotated section 175301 is amended by adding the following new subsection. Notwithstanding any other law, the board shall not discipline, sanction, or threaten to discipline or sanction any person for declining to celebrate or to officiate at a marriage or commitment ceremony that falls outside of the definition of marriage provided in this code. Meaning the Board of Judicial Conduct could not sanction judges who refuse to officiate at marriage ceremonies that fall outside the traditional definition of marriage. Now, since the bill states that the board shall not discipline any person, does that mean that a judge who upholds the right of an individual to refuse to celebrate or officiate at same-sex marriage would also be protected?